Welcome to this essential guide on navigating the H-1B 60-day grace period after job loss.
First, we will set the stage with what the 60-day clock really means.
Then, we will explore your legal pathways, how to vet attorneys under pressure, and a practical action plan. Finally, we will wrap up with key takeaways and next steps. Let's begin. Here is our agenda. We will cover the 60-day rule, your primary options, how to select legal counsel wisely, a day-by-day action plan, a checklist of documents, common red flags, and quick quizzes to reinforce learning. Let's move on with a crucial disclaimer. This is an educational video and not legal advice. Immigration law is complex and fact-specific, and policies may change. You should consult a qualified U.S. immigration attorney to obtain advice tailored to your specific circumstances. Nothing here creates an attorney-client relationship. If you are nearing or past the 60-day mark, seek professional counsel immediately. When your H-1B employment ends, a strict 60-day grace period begins. During this window, you must file an H-1B transfer petition, file a change of status such as to B2 or F1, or depart the United States. Failing to act within 60 days may lead to unlawful presence, which can have serious immigration consequences.
With that urgency in mind, let's clarify your pathway options.
Here is how the 60-day rule translates into action. If you secure an employer willing to sponsor you quickly, an H-1B transfer petition can be filed during the grace period. If the transfer is filed before day 60, you may be able to remain in the United States and, under certain conditions, begin working upon receipt of the filing. If you do not have an employer ready to file, consider eligibility for a change of status, such as B2 to bridge time, F1 if you intend to study and obtain an I-20, or H-4 if you have a spouse in H-1B status. If none of these are viable within the time frame, timely departure preserves your immigration record. After considering these pathways, we will now outline a day-by-day action plan. This step-by-step plan helps you convert urgency into action. Immediately confirm your termination date because that sets the grace period clock. Promptly contact recruiters and highlight your 60-day timeline to move interviews faster. Simultaneously schedule consultations with specialized immigration attorneys and prepare targeted questions. If a transfer is viable, have the new employer initiate the labor condition application and prepare a premium processing strategy where appropriate. If the search is extending, prepare a B2 or alternative change of status package as a bridge. Choose your attorney and obtain a clear filing timeline. Gather all documents, including prior approval notices, pay records, degree evaluations, and job descriptions. Submit filings with tracking and confirm USCIS receipts. Keep interviewing, consider multiple offers, and periodically reassess fallback options with your attorney. As day 60 approaches without a filing, plan a timely departure to preserve your record. Selecting counsel is pivotal. Seek flat fee structures to maintain clarity and avoid surprise billing. Ask for concrete evidence of successful H-1B transfers completed under tight deadlines. Require direct communication with the handling attorney rather than only paralegal contact. Finally, ensure the attorney proactively explores strategic alternatives such as B2 bridging, F1 study paths, or H-4 dependent options in case your job search extends beyond 60 days. Next, let us compare specialist counsel with high-volume processing shops. On the left, specialized counsel will emphasize a strategy-first approach tailored to your facts. You will have direct access to the responsible attorney and clear, transparent fees. They will evaluate and prepare alternative options in parallel. On the right, high-volume operations often rely on templates and multiple layers of communication, which can lead to delays and limited accountability. These firms may appear inexpensive up front, but can omit necessary strategic scope. Proactivity and precision are critical in a fast-moving 60-day situation. Now, let's ground this with a practical document checklist.
Here is a practical document checklist. Identity documents include your passport biographic page and your I-94. Immigration records include all prior H-1B approval notices. Employment evidence includes recent pay stubs and a verification letter. Education documents include degrees, transcripts, and any credential evaluation if your degree is foreign. Job evidence includes the new offer letter, job description, and organizational chart if available. Filing components include signed forms, a certified labor condition application, and any required filing fees. With documents in hand, we will next visualize strategy options.
This mind map highlights strategic alternatives. A straightforward H-1B transfer is ideal when a new employer can file promptly, preserving continuity. If timing is tight, a B2 bridge can provide a temporary lawful status while you continue your search, mindful of non-immigrant intent and timing. An F1 student path requires admission. An I-20, SEVIS steps, and budget planning. If you have a spouse in H-1B status, an H-4 could stabilize your status, noting that employment authorization depends on criteria. An O-1 is an option for individuals with extraordinary ability, but requires substantial evidence and lead time. When none of these align within your window, a timely departure helps maintain a clean record for future entries.
Before moving on, let's test your understanding with a quick quiz.
Question: which action best preserves your H-1B status if you have a new job offer during the 60-day grace period? Option A: file a change of status to B2 first, then consider a transfer later. Option B: have the new employer file an H-1B transfer with a certified labor condition application before day 60, ideally with premium processing. Option C: wait to depart and re-enter later when things settle. Option D: do nothing until day 55 to gather more documents. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video.
The correct answer is to have the new employer file an H-1B transfer petition, including a certified labor condition application, before day 60. Premium processing can reduce uncertainty by accelerating adjudication. Now let us reinforce your grasp of attorney selection with a second quick quiz. Question: which is the strongest indicator of a trustworthy immigration attorney in a 60-day crisis? Option A: lowest fee advertised. Option B: immediate access to the handling attorney and a clear milestone-based timeline. Option C: firm processes the most cases per year. Option D: promises guaranteed approvals. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video.
The correct answer is immediate access to the handling attorney alongside a clear, milestone-based timeline. These factors reflect accountability and responsiveness, which are critical under a 60-day deadline.
Next, we will visualize your overall time horizon.
This timeline illustrates the sequence from day 0 through day 60. Immediately after termination, you initiate outreach and consultations. In the first week, an employer begins the labor condition application if a transfer is viable. As a hedge, a B2 or other change of status backup can be prepared in days 5 through 10. Between days 10 and 20, documents are compiled and the transfer or change of status is filed. From days 20 to 45, you monitor the case while continuing interviews. Between days 45 and 55, you review contingencies.
Finally, if no filing is viable by day 60, you plan a timely departure to preserve your immigration record. Now, let us finish with red flags and a final summary.
Avoid letting time slip without a backup plan, particularly past day 45. Do not rely solely on paralegal communications for high-stakes strategy. Resist choosing counsel exclusively on lowest cost. The 60-day period is not flexible, so act decisively.
Finally, ensure filings are complete and supported by robust evidence.
Consider these scenarios. If you receive an offer by day 10, request that your employer initiate the labor condition application promptly and consider premium processing. If you do not have an offer by day 20, prepare a B2 bridge while continuing interviews. If your spouse holds H-1B status, evaluate H-4 and discuss employment authorization considerations. If you are approaching day 55 without a viable filing, plan a timely departure to protect your record and consider re-entry strategies later. As we conclude, let us summarize the essentials. To summarize, the 60-day grace period is strict, so act immediately. If you have an offer, prioritize an H-1B transfer. Otherwise, prepare a change of status bridge. Selecting the right attorney is crucial. Prioritize strategy, direct access, flat fees, and evidence of success. Maintain a day-by-day plan and keep backup options running in parallel.
If necessary, depart on time to preserve your immigration record.
Finally, remember this is educational information, and you should consult a qualified immigration attorney for advice tailored to your situation. Thank you for watching. If this video helped you understand the 60-day H-1B grace period and your strategic options, please like the video, share it with someone who needs it, and subscribe for more guides. Comment below with your questions or topics you would like us to cover next.